After 40 days of marathon hearing, today was the 40th and final day. Constitution bench has reserved the judgment to the Ram Janmabhoomi title dispute. This has been a non-stop 40 days of daily hearing here and now the Constitution bench reserving the judgment here to the Ram Janmabhoomi title dispute. Remember, it has been an intense day in court today. We will get you all those details and furthermore with these inputs here. This was very, very closely watched through the day today here. The Chief Justice of India had made it clear there would be no further extension. 40 days that were granted, it should conclude in 40 days. And now you have the Constitution bench there reserving the judgment to the Ram Janmabhoomi title dispute. Deputy News Editor Meenakshi Bhanja is getting us those inputs here. Meenakshi, this has been the final day in which we have seen, of course, all those arguments in a very heated manner taking up the final pitch here for this. Take us through those inputs, please.
Well, Seher, the big breaking news after marathon 40 days, this will go down in the history of the Supreme Court of India as the third longest argued case. This in itself is quite historic because we are into the 40th day where the Supreme Court just moments back has gone ahead and reserved its verdict on the contentious title dispute issue pertaining to who has ownership on that site of land at the Ayodhya Ram Janmabhoomi birthplace, which is considered to be of Lord Ram. Clearly matter which has several layers to it. This is something which is not simply a property dispute, although a large part of the Supreme Court's adjudication will be pertaining to ownership, and that is the issue which has been so hotly contested in the Supreme Court, with the Muslim side, the Sunni Waqf Board, trying to tell the Supreme Court, citing evidence after evidence, which it claims is something which has value in law, to showcase as to how the Hindu side has never had title rights on the disputed site. On the other hand, we have seen some equally sharp rebuttals coming in from top councils who have represented the Hindu side, Nirmohi Akhada, Ram Lalla Virajman, and another party to the side. They together comprised the Hindu point of view to this. They have maintained as to how even during the times of the British in 1856, 1857, the Hindus were given the right, at least till the outer courtyard, to go and offer prayers. But clearly, this is a matter which will go on to assume a lot of overtures. Of course, we know the political implications surrounding it and the social implications surrounding the matter. But the big news coming from the Supreme Court is as to how, after 40 days, the top court just moments back has gone ahead and reserved its verdict on the batch of pleas, which is claiming rights to the title on this contentious site. And again, this is the third longest argued matter, sir, in the history of the Supreme Court of India.
Absolutely.
Back to you.
And Meenakshi, given the fact that the Chief Justice of India made it very clear that there would be no further extension to this 40 days, in fact, it should conclude. All arguments, all voices, all sides should be heard by 5 p.m. today. Given the manner in which things were proceeding in court, inside the courtroom today, how has this come about an hour early? Is it because of the concern, the decorum in the court not being maintained?
Well, no, sir. Of course, we saw acrimonious exchanges in the courtroom today, but you know, that is something that does transpire. Of course, it is the bench which pulls up the lawyers when they engage in unprofessional conduct. And today, clearly, Rajiv Dhawan, who is senior advocate representing the Sunni Waqf Board, got carried away when he tore up these documents, which were in the form of these maps and other structural diagrams, which was submitted by the Hindu Mahasabha. And he came in for a very very sharp reprimand at the hands of the Honorable Chief Justice of India, who went on to say as to how the bench can simply get up and walk out if this sort of conduct continues. And obviously, he also noted as to how the lawyers, if they continue in this sort of unprofessional, acrimonious conduct, they go on to just waste the time of the Supreme Court, which is why, very quickly, a pertinent point here, Seher. Remember, like you rightly mentioned, the matter was supposed to go on till 5, and there was this aspect of a specific relief that was to be argued by each of the respective parties, which is called the molding of relief, as to what specific relief was being expected by each of the parties. Now, on that point, the Supreme Court has chosen to just go through the written submissions that all parties will file and not just hear the arguments in open courtroom. So that's a clear indication that the Supreme Court had this thing at the back of its mind, given the fact that we saw these acrimonious exchanges in the court today. But remember, this is not the first time in an issue of this magnitude, especially the Ram Janmabhoomi title dispute issue, that we are seeing acrimony, exchanged in the courtroom. We have seen that in the past as well, during the tenure of former Chief Justice of India, Justice Deepak Mishra. Even that point in time, there were heated exchanges. Even during the time of Honorable Justice J.S. Keher, the then Chief Justice of India, we had seen sharp exchanges. But today, the tearing of documents is something that will perhaps be seen as an overreaction on part of Rajiv Dhawan, representing the Sunni Waqf Board. But immediately, he was castigated, pulled up and reprimanded by the Honorable Chief Justice of India. So 180 hours of cumulative hearing spread over 40 days, Seher, results in this case being perhaps the third longest argued / debated case in the history of the Supreme Court. Now is seeing the reserving of the verdict, which in all probability is now likely to be pronounced on or before the 17th of November 2019, because that is the day the Honorable incumbent Chief Justice of India, Justice Ranjan Gogoi, is all set to retire, Seher.
All right, yet another important input here coming in. The date of the verdict would be closer to the time on the date 17 November when he's set to retire, and before that the verdict would be given out. The longest hearing, non-stop 40 days in the Supreme Court is what we've seen here. But Meenakshi, this has been an extremely exhaustive procedure that we've seen play out in courts even before it reached the stage of the Supreme Court. In multiple petitions from different parties that were filed, bunched together to be heard, in multiple parties that were heard in these arguments here. What has been the big takeaway in these 40 days?
Well, yes, Seher, there have been a lot of issues that have been dwelled upon, which has been exhaustively argued by both sides. But to really surmise it for the sake of our viewers, 2 or 3 most important aspects will have to be scrutinized by the Supreme Court, whether or not Hindus have had title rights over this place. Secondly, whether or not, despite the title right issue not, according to the Muslim side, not being something which is critical, the Supreme Court has been urged upon to look at it as something which is pertaining to the faiths and the beliefs of the people. And thirdly, a lot of historical evidences have been submitted before the Supreme Court by way of by way of notings of travelers to India, which dates back to even the British times. Like, for instance, there has been data that has been submitted by way of these written notings from 1850s, Seher, which shows that Hindus had access to at least the outer courtyard to offer their prayers, and therefore it was the Muslim side also which accommodated this religious faith and belief of the Hindu party to allow them access inside the premises to pray way back in 1856. Again, that was a point which was sharply disputed by Rajiv Dhawan for the Sunni Waqf Board, saying that that was something which was done for maintaining public peace, public tranquility, public order, that in no way goes on to define the rights of the Hindu side as having complete title rights on that contentious side. And the other important aspect which the court will scrutinize, of course, it will all reflect in the final verdict, Seher, as to whether or not that particular spot, which is now referred to as the Janm Sthan, is something that is exactly the spot where Lord Ram was born, which falls beneath the top dome of the masjid. According to the Muslim sides, while it is acknowledged that Lord Ram was born somewhere in Ayodhya, the exact spot of his birth is uncertain. So, sharply divergent points of view, Seher. And the other
Okay,
important aspect.
that's right. All right, these are further breaking inputs here regarding the Constitution bench, which will order on the recusal of Justice Mishra on October 23rd, and this after the judge, Justice Arun Mishra, stood firm against a request by parties to recuse himself from heading a Constitution bench meant to re-examine his own argument. This was in February last year. Justice Mishra authored a majority judgment that conflicted with a 2014 verdict of the court on grant of compensation, which is under Section 24 regarding the land acquisition law of 2013. Okay, this is an interesting detail on another issue here coming in. Deputy News Editor Meenakshi Banja to explain this further to us here on this. Yes, Meenakshi, go ahead.
Well, of course, this is a different issue pertaining to Justice Arun Mishra heading this Constitution bench, which will go on to examine, amongst other things, Section 24 provision of the Land Acquisition Act. Now, it was Sunday that a lawyer's body wrote a letter saying that Justice Arun Mishra's point of view on this issue is definitively known, and therefore he should not be heading this bench. He should recuse himself. But we have seen some dramatic developments pertaining to arguments that have come by since yesterday. We are also in the know of some very strong reactions from Justice Arun Mishra himself, who went on to say, and I quote Seher here, that this sort of a demand for recusal is something that tantamounts to influencing outcomes in critical matters. And he today went on to observe, and I quote, "I am telling you clearly, this should not, must not, and shall not be this way," unquote. "We have to protect this institution. Onslaught is going to tame the institution," unquote. So according to Justice Arun Mishra, this is seriously something which is deeply nefarious. There are other powers behind such sort of demands for recusal, and this point of view of Justice Mishra's today has been supported very, very strongly by the learned Solicitor General, who is one of the top law officers of the Government of India. He is arguing in favor of Justice Mishra, opposing the demands for his recusal. So the government clearly is batting for Justice Mishra to continue in this particular matter. Solicitor also went on to today add before the Supreme Court as to how this sort of forum hunting or bench hunting is something which has to be tackled and dealt with very, very harshly. So on this issue, we have seen Shyam Devan, a very eminent senior advocate who our viewers will recall, was also heading the matter when the Aadhaar debate was ongoing in the Supreme Court. He is of the point of view that there should not be even a hint of bias in the minds of the litigants, and even if a hint creeps in, it is for the judges to recuse themselves. So we have 2 points of view, where the judge of the Supreme Court himself is saying that there are attempts underway to impact outcomes of critical matters. On the other hand, we have Shyam Devan for the petitioners, who are saying that even if a hint of bias creeps in the litigants' mind, the judges are duty-bound to recuse themselves. On this point of law, the Constitution bench will pronounce its verdict whether or not Justice Mishra should recuse himself on the 23rd of October. Seher, back to you.
Okay. All right. Meenakshi, many thanks for getting us those details.